started. I am screen sharing. I am going to share the screen with you, and hopefully everyone will be able to see that. Can you see the screen? Just say yes, Rachel, or no. Yes? Okay, good. All right. The reason why we are here today is to cover some topics which are part of a resolution agreement with the Office for Civil Rights. And so Office for Civil Rights has agreed that I can present to y'all as part of this agreement. I'm not going to go into the details of the agreement. Suffice to say that part of it requires the training of many staff at many schools. And so we've got topics to cover. And so if there's some information that you feel like you need, again, you could follow up with Rachel if you have some additional questions. So the title of this is Section 504 ADA, IDEA, and non-discrimination. So at the moment, this will not advance. Let's see. There we are. Sometimes it's finicky on Zoom. So why are we here? As I indicated, the United States Department of Education Office for Civil Rights, they are responsible for monitoring and enforcement of various civil rights laws. There are multiple laws in which they enforce federal laws, and one of those is Title VI of the Civil Rights Act of 1964. And a quote from that federal statute is, "No person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." There are Tangipahoa Parish School Board policies which relate to this, including policy JAA, JA-R, JAAA, and JCD-AFA. So I would encourage you to review those policies as they apply to the entirety of the school district. And you as employees, and especially as administrators, have obligations to be aware of these, familiar with them, and be able to implement them appropriately. Parent and student resources. If a student or parent believes that they have been subjected to discriminatory treatment, and a grievance may be filed pursuant to policy JCE. Concerns may also be brought directly to school administration. Any complaint of discriminatory treatment must be fully and completely investigated with appropriate action taken in accordance with the outcome. What is a very important component of responding to an allegation of discrimination has to do with engaging in a timely and unbiased, objective investigation. And then also with appropriate action taken in accordance with the determination of that investigatory process. I'm going to first talk about Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. These federal statutes are basically twin statutes for, in all intents and purposes. There are some differences. However, the core of both of them for purposes of this presentation is that they require all students with disabilities to be shielded from discrimination on the basis of disability. The federal statutes, ADA and 504, require reasonable accommodations and services to provide equal access to programs, services, opportunities, and activities of the school district. And it includes all academic and non-academic activities, such as in the classroom, transportation, extracurricular activities and sports, and before and after school programs. Include, the term there does not mean that the following list is exhaustive. Those are just examples. So if there certainly are other academic and non-academic activities in which the school district engages or sponsors, those are covered under 504 and ADA as well. Another federal law which pertains to students with disabilities is the Individuals with Disabilities Education Act of 2004. And the purposes of IDEA are to provide a free, appropriate public education, or FAPE, to meet the needs, prepare for future education and employment of a student with a disability, to ensure the rights of students and parents, excuse me, are protected, and to provide education to all children with ages 3 to 21 who have been identified as having a disability under IDEA. And the fourth component of IDEA is to assess and ensure the effectiveness of efforts to educate students with disabilities. Some critical components of Section 504, ADA, and the IDEA. These are really common elements as pertaining to students within your school system. First is a child fine mandate. The child fine mandate has to do with the obligation of every public school system to locate, identify, evaluate, and provide services to students who have disabilities within your jurisdiction being your parish, Tangipahoa Parish. So whether they attend public schools, non-public schools, or homeschooled, you have an obligation to identify, locate, identify, evaluate, and provide services to students. Now, that requires parental consent, and then also services are contingent upon a student being a student within your school system. I mean, they can be a student in a non-public school or in homeschool, but in order to be entitled to services from the school district as far as provision of FAPE, they would have to be enrolled in one of your public schools. Annual notice to parents of procedural rights. That's at least annual notice. There are components of the law that require you to provide notice to parents of procedural due process rights more frequently, such as at team meetings and after written notices that are required under federal and state law. Another critical component of 504 and IDEA has to do with making decisions by a group of knowledgeable individuals, that group being a team of knowledgeable individuals. Individual decision-making is not something that is a characteristic of the law. The team includes the opportunity for the parent to be part of that decision-making, and so it is always appropriate to be bringing together multiple individuals who have knowledge of the student, knowledge of services, have special expertise in areas such as speech or mental health or health, such as a nurse, and other individuals such as, of course, educators, regular and special educators, interventionists, to make team decisions. Another component of the IDEA and 504 is that services are to be provided in the child's least restrictive environment. Least restrictive environment means that the student is provided services in an environment where they have access to peers without disabilities to the maximum extent appropriate, and also be making meaningful educational progress. So the least restrictive environment may be the regular classroom for many students, but for other students, the least restrictive environment may be what is often called a resource setting or a self-contained setting. It may be a special school. It could be a residential placement. It could be a therapeutic day school. So the least restrictive environment is something that is specific to the child and the child's individual needs at that time. Another component of 504 and IDEA has to do with a plan. We have a written plan that is a requirement of IEP 504 plans. It's not required, but everybody does do a written plan, which is a great idea. Is that it must be implemented, and it must be implemented with fidelity, which means it's implemented as written. Another responsibility of the school system is prior to a significant change in the student's placement, such as due to disciplinary reasons, there must be a reevaluation prior to that change in placement. That reevaluation must follow the rules associated with, for kids under 504, the 504 reevaluation process. For students with disabilities under IDEA, it must follow the reevaluation process in Louisiana regulations, which are specifically found in Bulletin 1508. Both students under 504 and IDEA are entitled to a manifestation determination review if there is a proposal to change a student's placement on the basis of discipline. So there's a very narrow exception for some number of kids under 504, but for all intents and purposes, an MDR is a general requirement under 504 and is mandatory in all circumstances under IDEA. And for both of them, again, when you are considering a disciplinary change in placement, and then as I've mentioned before on a prior slide, it is required under both 504 and under IDEA that students be offered, and if the parent consents, to be provided a free appropriate public education. Resources that Tangipahoa Hill Parish School Board has examples of these resources are found on this slide. You see you have Brooke Kelly as a 504 coordinator, Rachel DiBenedetto, special ed coordinator, Susan Dubois, pupil appraisal, Bobby Matthews, ADA. There's Section 504 compliance documents. There's a grievance ladder. There's information regarding students with dyslexia. There's a parents' rights booklet, and also a listing of parent resource centers. And all of these are available on the school board website. If you have any questions, of course, please reach out to them and they will be glad to assist you. So let's dig in a little bit deeper into Section 504 ADA and the IDEA. So when you look at a sort of a diagram of all children, which is the big red circle there, there's a smaller, and this is not necessarily proportional to the number of kids who would have disabilities. It's just for graphic purposes. You're going to have a much smaller circle of kids who are eligible under 504. And then within that, you're going to have a smaller number of students who are going to qualify under IDEA. However, the reason why the yellow circle is within the blue circle is that it is considered that because, or due to the fact that students identified under IDEA are children with disabilities, that they are entitled to the protections under Section 504. Again, the focus of ADA and 504 is on non-discrimination on the basis of disability. So this slide here on 13 has to do with the comparison of mandates. And so if you look through here, was child find, non-discriminatory assessment, multi-source, placement team, FAPE, all of these is basically the same by and large. There's discipline protection have an asterisk there with regard to one specific exception. If you have a question about what that exception is, you could reach out to Rachel, and then we could discuss that. But under eligibility is really the only significant difference in how kids are qualified under IDEA and 504 ADA. Bulletin 1508 of state regulations for eligibility for students with disabilities under IDEA. 1508 also has the mandatory establishment and procedures for school building level committee. So that section 300, specifically 303, is something of which you need to be very familiar just generally because it has much more to do with just general ed process than it does specifically special ed. And then also, it also has procedures with regard to screening. And of course, Bulletin 1508 encompasses students who are gifted or talented or suspected of those exceptionalities. In Louisiana, we take kids with disabilities and under IDEA and gifted and talented and put them under the umbrella of kids with exceptionalities. But for purposes of this presentation, I'm going to be speaking of kids with disabilities. That's not to say that kids with gifted and talented cannot also have a disability, and that many of them certainly do, or are entitled to services under either 504 or IDEA, depending upon the nature of the disability. So further comparison, excuse me, between the two, again, you see there being a lot of similarities. The only currently, the only other significant difference between the two, other than, as I said before, the eligibility criteria, has to do with the state complaint procedure. There is a state complaint procedure under IDEA. There is not one because the state does not currently have any law or regulation specifically with regard to 504, nor does the federal law require one. So let's talk about child find and eligibility. So under 504 and ADA, a disability in the one of three criteria. The first being the one that is truly the path to a student getting a Section 504 plan is criterion A, a physical or mental impairment that substantially limits one or more major life activities of such an individual. Also, children who have a record of such an impairment or being regarded as having such an impairment being one that is substantially limiting of a major life activity, are all eligible for the anti-discrimination protections of 504 and ADA. So what are some examples of major life activities? Well, major life activities include caring for oneself, manual tasks, a whole plethora of other types of activities. And then also what is a major life activity is also a major bodily function. So essentially any bodily organ or organ system is a major life activity for a child. And so as you can see, immune system, brain function, digestive, certainly many children who have immunity problems, brain function, have gastrointestinal issues, diabetes, various forms of diabetes, etc. So these are only examples. IDEA, 504 and ADA are written to be construed very broadly, so that it's not like, well, I can think of one that's not listed here. More likely than not, it's going to be a major life activity. And so that's not really of tremendous concern, as if it's something that impacts a child and their activities at school and their ability to function educationally, it's going to be a major life activity. So in 2008, which became effective in 2009, the Americans with Disabilities Act modified both not only the Americans with Disabilities Act, but also Section 504 to include impairments that are episodic or in remission. Those conditions, if when they are active, or that is affecting the student, sort of the symptoms expressing themselves, would substantially limit a major life activity, then those. And so some examples, episodic conditions could be migraines, gastrointestinal issues, shingles, and then in remission could be any type of condition where the child had either has gone into remission spontaneously or with treatment, such as various cancers. And so don't exclude a student who, just by the nature of, well, we don't hasn't had has been asymptomatic for a long time, is not necessarily going to be removed from consideration of having a disability under ADA and 504. But just going back to the definition again, having an impairment in of itself is not sufficient. It has to be an impairment of a major life activity, and it has to be substantially limiting. And we'll touch upon that in a moment, what substantially limiting means. Well, how many major life activities need to be affected? Well, it only needs to be one. But what is a very important concept here is to understand that you cannot focus solely or exclusively on learning. The major life activity can be something other than learning. As you can see from the examples, many of these have little to nothing to do with learning per se. You say it might be associated with it, but it doesn't have to affect a student's grades. You can have a student who's doing phenomenally well, could have all A's, has never gotten a B in their life, and you can have a substantial limitation in a major life activity. You could have those that are tremendously successful, but grades are not determinative of whether the child has a disability under ADA and 504. One other very important component of the eligibility process for students under Section 504 is that you may not use the effects, ameliorative effects of mitigating measures when you are doing an evaluation for a student who is suspected of being eligible under Section 504, that you suspect a disability. And what that means is, effectively, you need to look behind the intervention. And as you can see from the graphics there, is that any type of supportive support, such as a walker, pharmacological, medical intervention, any type of assistive technology or device that a student is using, you cannot consider that except for ordinary corrective lenses when you are making a determination of whether the student has a disability under Section 504. Well, you think that sounds pretty difficult, is to say, well, how do you know? How do you know what the kid looks like without intervention? Well, that's when you're having to dig into the child's history, talk to teachers who knew the child last year, many years ago, talk to the parent. Again, getting those multiple sources of information to determine, well, before the intervention, what was the student like? So you're basically having to, as a team, do some pretty educated guessing to see whether prior to that intervention that physical or mental impairment substantially limited a major life activity. What you cannot do legally is ask or require the parent to remove that mitigating measure. That is completely impermissible legally, especially with regard to medication. So you don't go there. So in those instances, generally, you'd say you're going to probably err on the side of qualifying the student. So what is important is say, well, what if the kid doesn't need anything? How could they qualify? Well, there's an impairment. And if you look back and say, well, yeah, we actually knew the kid prior to um, type of interventions that have been provided. And yes, well, yeah, really, we really believe based upon what we have documented and we recall that this student's major life activity was substantially limited. Um, and the point being here is that you say, well, why would a kid who doesn't appear to need anything get a label of Section 504? Well, that's the whole or part of the main purpose, not the entire purpose, is that, again, you're identifying students who have a disability for anti-discrimination protection. 504 and ADA really are not about, at least in their core, about getting stuff. It's really to prevent a public entity like a school system from treating that individual in a discriminatory in a way which is inappropriate legally, that there's no legitimate non-discriminatory basis for treating them that the way that you would treat them. So it's a matter of protection as opposed to saying, well, they don't really need anything. So it is possible that a student could qualify under Section 504, and then their plan may be not a whole lot. So in some instances, it may be that the student's health plan is what is the plan and nothing more. Now, a question is, well, how important does the major life activity need to be? Well, it doesn't need to be of central importance to most people's lives. It just needs to be something that the child needs to engage in, that maybe an adult is not of central importance or even importance to an adult, but is something that is very important to a student. Now, what you would not see on that list is taking standardized testing during the spring, but for at least for kids in Louisiana and many other states, taking those big standardized tests in February, March, April, and May of the school year is certainly a major life activity, at least arguably that it is. So what about if a kid has like a broken leg or gets a concussion or something like that? Is that really, can they actually qualify for 504? Well, the ADA speaks of what is called a temporary and minor impairment. Really, the term that is used within the ADA is transitory. So if a condition is transitory and minor, transitory being a duration less than 6 months and minor, then the student would not qualify generally. However, the duration and severity of an impairment are factors to consider. So what you need to be careful when you're making determinations, when a 504 team or whatever you may call your team, it could be the SBLC, when you're making these determinations, do not categorically exclude, oh, well, that's just a broken leg. Well, certainly you should be well aware that not all broken legs are the same. Well, he had a mild concussion. Well, that's what you may think. This may be something where the student is experiencing symptoms for quite a while. One that is important, that is really something that has come to the fore in recent years is the what's called long COVID. And so say, oh, well, that kid had COVID a couple of years ago. They're fine now. But what's been found is that many individuals of all ages, not just children, but certainly children and adults, can still experience long-term symptoms of various and a whole variety of symptoms long after they had COVID or may have had COVID. I mean, it may be You may have been asymptomatic, and then you're symptomatic, may have known that you may have never known that you had COVID or only suspected. So you have to look at these conditions on a case by case basis. So don't exclude a kid to say, oh, well, that's just a broken arm, broken leg, mild concussion or such. You have to look at it on its own merits. So how does this get done generally? Well, as I said, SBLC, something that's required under Bulletin 1508, Section 303. It is a general ed-based decision-making team that's going to review and analyze academic and behavioral information, data, develop instructional and disciplinary strategies and interventions for addressing students' needs, and then makes decisions with regard to whether a student may need to be, if they're suspected of having a disability under 504, to go to a 504 evaluation path, or suspected of having a disability under Bulletin 1508 under IDEA, then going down the special ed evaluation path. The SBLC responsibilities, you've got principal, classroom teacher, and referring teacher. Certainly, you're going to have many other individuals who are typically going to be part of this, such as a school-based 504 coordinator, if the SBLC is your conduit for doing 504 evaluations. And then if the kid is being considered for evaluation for special education, a representative from pupil appraisal must be there. And then SBLC is responsible for coordinating and documenting the results of all screening activities. Parent participation, parent or guardian should be invited. And whatever efforts you have made to try to encourage parental participation should be documented and maintained. Don't get rid of any of that, because it'd be very important to maintain that information. You have to provide written updates on all SBLC activities at least every grading period. So every 9 weeks, if you're on a 9-week, every 6 weeks, you're on a 6-week. It can be more frequently. So if a kid is in intervention, and we're coming up now, this presentation is October 7th, coming up on the first 9 weeks. You got a kid who's been in SBLC, you need to give a written update on what's going on with that student. There's no magic content for that. If you do have a specific form, then utilize that. Otherwise, provide a brief narrative to the parent, or say brief, just enough to describe what's going on. Progress in RTI or screenings, whatever it may be that you're doing with that student. And then you also need to communicate in writing to the parent any issues with regard to identification and evaluation. That must be done in writing. And when you're making those communications, please include a copy of the appropriate rights booklet, whether that's 504 or the SPED rights booklet. Please be aware that diagnosis by a physician or a psychologist cannot be the sole source of information for a 504 determination, nor can it be for special ed. It cannot, getting it, if you say, well, we need to get it, it cannot delay the evaluation. It would be inappropriate to say, well, once you get the doctor's diagnosis, then we'll begin the evaluation process. That would be in direct violation of 504. And if the school district says, well, we absolutely have to have whatever that evaluation is, whether it's from a physician or a psychologist or what have you, then you're going to have to pay for it. That is, the school district's going to have to pay for it because recall the F in FAPE, which covers identification and evaluation, is free. As I mentioned previously, is that grades are not determinative of whether a student has a disability or not. They are alone insufficient to determine disability status. They are a single piece of information which can be useful, but again, because a kid has all A's does not mean that, well, no, they can't be 504. Well, why? If this has absolutely nothing to do and doesn't need to have anything to do with learning, it may be that you're talking about a student, a girl, young woman who's got severe diabetes. She's got all A's, she's doing beautifully in school, no behavioral issues, no social issues. Academically, she's doing beautifully. That she happens to have all A's is not a barrier for her to be eligible for 504 because she's got a major bodily function, which is substantially limiting diabetes, endocrine system, what have you. And so she can qualify for 504. Now, in contrast to the eligibility criteria for 504, very different under IDEA. So under IDEA and then the state criteria in Bulletin 1508, the two conditions must exist. Educational assessment data must indicate that the child meets criteria under one of the disabilities and by reason of that disability has a need for special ed and related services. The major contrast here between 504 and IDEA eligibility is for 504, number 2 doesn't exist. That is not a criterion for eligibility under 504. There does not need to be a need for services. Under 504, you just need to meet the criteria in A, which is a mental or physical impairment that substantially limits a major life activity. So FAPE requirements, you have a duty to provide FAPE for a kid under 504. You have a duty to provide FAPE under IDEA. Obviously, athletics and extracurricular activities are part of the educational experience of students at all grade levels. They are very important and they teach some very important life skills. And for students with disabilities, they must be provided an equal opportunity to participate. Reasonable accommodation and modifications are required. Substantial alteration is not required to an activity for a kid. Let's say you have a student who's in a wheelchair. Well, do they have the opportunity to try out for a sports team? Absolutely. That doesn't mean that they get onto the team, but they have an opportunity to participate in a process. To say that no, you can't go, you can't even try out for the basketball team because you're in a wheelchair would be discriminatory on the basis of disability. Going through and saying, well, you have to be able to walk and run to be part of the team, then that's a legitimate non-discriminatory basis for not making the team. And even if they weren't in a wheelchair, if they had some mild orthopedic issue, maybe they just do not have the skill level or the stamina level to be able to meet what's necessary to get on that team. The key is that the student has an equal playing field, but not an unfair advantage. And sometimes it's difficult to manage that conceptually, but if you ever do have any questions, please reach out to your 504 and your ADA. People, field trips, you have to provide reasonable accommodation. Can you require a parent who has a child with a disability to accompany you on the trip? Absolutely not. If the parent volunteers to do that truly voluntarily, well, absolutely. But you cannot require a parent with a child with a disability to come on a field trip unless it's required of every parent to be on that field trip. Development of the 504 plan and the IEP. Well, the team determines the services, the accommodations, related services, whatever it may be within that plan for FAPE for that student. You're documenting eligibility. You have individuals who can bring, as I said, expertise with regard to their particular areas such as social work, speech, occupational therapy, and otherwise. Teachers of the student with their expertise in instruction. And you must consider all relevant data information. And then you look at all of the components. You go through the entire process of determining what is going to be an offer of FAPE for that student within that plan. Plan implementation, I mean, it's enough, one, here to develop it, but then you have to implement it. Whatever you're doing, documentation of what you are doing and have done, providing services to the student is absolutely imperative. Everyone who is responsible for implementing that plan need to have full knowledge of the whole plan and also need to have the ability and the knowledge and the ability and the resources to be able to implement it. And so that includes service providers, it includes administrative staff, it includes teachers, and it also includes substitutes. So substitutes need to be aware of what's in plans. If they're not they don't know what's in a plan, they can't implement it. If you fail to implement, then you run into the risk of incurring liability legally. You run into what can be considered deliberate indifference, which can be a path toward monetary damages. And if the student is not progressing and there's evidence of lack of implementation, then you're going to have a denial of faith. You have basically a reviewer is going to have very little, excuse me, very little doubt that, well, you didn't implement it, it wasn't making progress. We don't know whether the student would have made progress because you didn't implement it completely. That's not to say that any failure to implement is automatically going to be a denial of faith or automatically going to expose the district to liability, but it's just better to implement with fidelity always. And if there's an issue, there's a barrier to implementation with fidelity, then it is imperative that you seek resources from school administration, central office administration, coordinators to be able to get in and make sure that whatever is a barrier to implementation is rectified as soon as is feasible. 504 plans and IEPs are distributed. You must sign acknowledgement that you have received the plan, that you've reviewed the plan, that you understand the plan, and then also understand that failure to implement a plan can lead to disciplinary action up to and including termination. So it's not only exposure in a legal sense for monetary damages potentially and the district incurring liability, compensatory education to the student and otherwise, it can also lead to personnel consequences. It cannot overemphasize the need to document. If you don't provide evidence of providing accommodations, that's really unfortunately, there's going to be a presumption that you failed to implement. I've had multiple cases, OCR complaints with other school districts where there's a allegation of failure to provide accommodations. And if the district does not have the evidence to show that it implemented the accommodations and services, not just accommodations, but other services, then OCR fines against the school district. And so it doesn't matter how you do it. And there are many ways that you can. What's critical is that you just do it. So tips to avoid implementation failures. As I've said before, and has been stated on at least one of the prior slides, is that teachers and staff need to understand what their responsibilities are under the plans. Those of you in administrative roles, supervisory roles, I mean, even a teacher is going to be in a supervisory role for a paraeducator, paraprofessionals, is that review the plan with individuals to say, it's one thing to say at a meeting, well, you understand what you're supposed to do. Yeah, I understand that I'm supposed to do X, Y, and Z. Follow-up question, which is critical, and you may want to do this individually, is do you know how to do that? Because it could be quite embarrassing in a group to say, well, you know what you're supposed to do. Yeah, well, do you know how to do it? You don't want to put a person in a position saying, no, I don't know how to do it. However, they need to know how to do it. And you, as an administrator, principal, assistant principal, central office administration, part of your obligation under federal law, especially with regard to IDEA, is to supervise the provision of services. The kids in your school, they're your kid. The district central office staff assists in that process, but you are a critical component, principals, assistant principals, in ensuring the effectiveness of efforts to educate children with disabilities. And that is one of the core components of FAPE, ensuring the effectiveness of efforts. That has to do with implementation of 504 plans and implementation of IEPs. One major implementation pitfall has to do with regular ed teachers and especially temporary instructors or especially further substitutes not knowing what students are to receive as far as accommodations and other services. It is imperative that everyone know what they're responsible for, and to document that they have received it, reviewed it, and know what they're supposed to do. If they have a need to understand, then have them meet with a behavior interventionist, school psychologist. If they don't know how to do something with regard to an educational academic intervention or something to do with an assistive technology device, then please have that person reach out to a service provider and have them come in and work and collaborate with them to get it done. Because it's that important. It's actually one of the core legal responsibilities in reviewing whether FAPE has been provided, is whether there's coordination and collaboration of all of the individuals who are responsible for instructing and providing services to the child. And if the school district cannot demonstrate that there has been coordination and collaboration, then you're very well down the road toward a denial of a free, appropriate public education. Not implementing, in addition to exposing the district and exposing individuals to personnel consequences, let's not forget about the student. The student's educational progress may be affected, and then may lead then to the student parent taking the student out and finding private, non-public resources, and then indicating to the school system, you're going to need to pay for it. And in some instances, if it's demonstrated that there's been a denial of FAPE, parent can get funding and reimbursement for private services, and not just non-public schools, but private services from providers and clinics of all sorts. So avoiding implementation failures is, again, cannot overemphasize the need to document your activities. Also documentation for students who refuse to take an accommodation. And this tends to be more common in students as they get older. They tend to not want to be singled out or have attention brought to them as they get older. Say some interesting things happen during the early part of the teens. Kids change, and then somehow that they don't want the accommodations that they've had for quite a while. Also, what is important to think about is, does the kid actually need the accommodation? Perhaps it's been a while or even recently that it really kid doesn't need it anymore. Nobody's really taken a look at whether they still need it. Just because it gets put on a 504 plan or on an IEP does not mean that the accommodation lasts forever. hopefully it's understood, or you recall, and if you don't recall, that you now understand that you're providing services and accommodations based upon an identified need of the student. It's not about benefit to the student. It's about whether the child needs that accommodation or service to receive a free, appropriate public education. Let's talk about discipline protections for a few minutes. As you may be aware, is that kids with disabilities under IDEA and Section 504 by federal law are provided additional disciplinary protections. Categorically, an expulsion is a change in placement triggering an MDR. And students with disabilities, while they may, an expulsion decision may be upheld that they committed an act that they said, that the principal said they did, they cannot be expelled for behavior that is a manifestation of their disabilities. However, you can, for up to 10 school days within a school year, suspend a student without parental consent, without providing services, unless you provide services to kids without disabilities who are under such discipline, without conducting an MDR and without convening an IEP team meeting. However, on the 11th day and any time further, the student must receive a free, appropriate public education in order to, which means to enable the child to progress in the general curriculum. If you're looking at suspensions of 10 days or more, you must convene an MDR. You must be looking at a functional behavioral assessment and behavioral intervention services to address the behavior that prompted the suspensions or the long-term suspension or expulsion, and you must provide behavioral safeguards. MDRs are conducted by relevant members of the 504 or relevant members of the IEP team, and you're required to review all relevant information in the student's file, including any information provided by parents. Teacher observations are very important. Prior evaluation and assessment, the plan, the BIP, the health plan, all of the various plans and other education records. The two questions that need to be asked and answered: was the behavior caused by or have a direct substantial relationship to the student's disability? And then also, was the behavior a direct result of the school's failure to implement the IEP or 504 plan? So the fidelity of implementation, you can see how that can be absolutely critical to answering that second question. So if the students, if it is a manifestation of the student's disability, then the student must return to the educational placement from which they were removed unless the parent agree otherwise. And then you must conduct a review, the FBA and the BIP, and you have to take any other actions that are necessary to ensure that the child is receiving FAPE. If it's not a manifestation of the kid's disability, then the student may be subject to discipline in the same manner and duration as other students. However, you still must provide FAPE, and as appropriate, an FBA and BIP must be developed to address the behavior so that you attempt in a meaningful way so that that behavior does not recur. Now, the exception that I mentioned earlier in the presentation has to do with one of those disciplinary protections that's not available to a student under 504 is an MDR is not required if it's a drug and alcohol related offense and the student is determined to be a current user of drugs or alcohol. If the team does not believe the student is a current user, then you would do an MDR. If a child is suspected of a disability, they have the same disciplinary protections as a student who is already identified. And so the LEA must consider the student to have a disability for purposes of disciplinary protections, but if before the behavior that precipitated the disciplinary action, the parent expressed concern in writing to an administrator or teacher, the parent requested a 504 or a special ed evaluation, or the teacher or other school personnel express concerns about a pattern of behavior to administrators. Now, procedural safeguards, I've mentioned these several times. There are many of them, and we're going to cover some very briefly here. Is students with disabilities and including students under 504 entitled to certain procedural protections with regard to identification, evaluation, placement, and the provision of FAPE. Procedural safeguards include notice, which is written notice. If it is not in writing, then it is not notice for purposes of at least IDEA, and by extension, if it's not in writing, then it really isn't notice under 504 either. The opportunity for the parents or guardians to examine relevant records. 504, there is an opportunity for an impartial hearing with participation by the parent or guardian. The parent or guardian can be represented by counsel at the parent or guardian's expense, and that if there's a review procedure after that hearing. Again, under 504, you must give notice of procedural rights at least yearly. It should be provided at every 504 meeting, and I put in there at IEP, you're going to give the educational rights to the parent at every meeting. Many times a parent can say, I already have one, or I've got 50 of them. Please document on that 504 plan or on that IEP that you offered the rights booklet to the parent and that the parent declined to take it. Just kind of push it into the middle of the table. They don't take it. Then if the parent says, no, I don't want it, just make sure that you've documented that. Because the parent could come back and say, oh, well, I was never offered it. It's like, no, right here, you recall we offered it. Oh, well, I don't remember that. But you remember, you as a district remember that because it was written in the document. If you are proposing or refusing any action, I mean any action with regard to identification, evaluation, placement, or provision of FAPE, you must provide a copy of the procedural due process rights. And whenever you propose or refuse an action, that's where, going back, notice is key. And again, notice is in writing, and you should include very specific components in those notices when you are proposing or refusing an action. Please contact your 504 coordinator, or for purposes of special ed, please contact your special ed administrators with regard to the content of those notices. Parent or student remedies. Well, internal grievance procedures. You can have internal grievance procedures. However, they may not be considered to be a prerequisite to an OCR complaint or a 504 due process complaint. And certainly common issues have to do with harassment or different treatment, including potentially bullying, and then also lack of accessible facilities or programs. Internal grievance procedures are certainly designed to resolve complaints promptly and equitably. Hopefully, the parent will sort of refrain from going, but please do not say to them, don't file an OCR complaint, we'll deal with it internally, or don't file, do this, because it will be potentially seen as retaliatory. The parent's going to do what the parent's going to do. You go through a process, perhaps even when you're going through an internal grievance process, the parent may have already filed a complaint or due process. Due process complaints are formal proceedings presenting evidence and witnesses. Adverse findings by the hearing officer, administrative law judge are going to be remedies such as compensatory education, restitution, private tuition, all those kind of things. The Department of Education pays for a due process proceeding under IDEA. The school system pays for the cost of a 504 hearing. As I indicated earlier, the Office for Civil Rights is responsible for monitoring and enforcing various civil rights laws, including, of course, 504 and ADA, Title VI of the Civil Rights Act, Title IX, and the Age Discrimination Act of 1975. An OCR complaint, parents can file. There is typically early complaint resolution, or they may go to investigation. If there's an adverse finding, there'll be a resolution agreement, even when there's not an adverse finding. There are times in which, and it's OCR's decision, where they will allow for a resolution agreement to try to bring to closure some issues that they have found during their preliminary review of the complaint and the data that is provided to the school system. Certainly, there is an option if there's a 504 ADA issue. Parent may file a federal lawsuit, a complaint, it's called, in federal court for discrimination, and they don't need to go through any type of exhaustion process as you might have to do through IDEA. And certainly monetary damages are among the relief that you can get in federal court. Okay, well, I think I made it in about exactly an hour or a minute over. So I appreciate very much you taking the time to do this in your very, very busy schedules. And so I will be sharing this, of course, with Rachel and getting it to your staff. If there's somebody who you thought might have been able to participate today but was not, actually the majority of individuals who are going to view this are going to view it at another time. So at this time, I'm going to end the meeting, and I hope you all have a very good afternoon.